All right. We're ready in a minute. We'll let everybody in. Can you hear me, Rose?
I can hear you. Can you hear me?
Yes. Excuse me, we are streaming. And I will, Rose, if you'll call court and then I'll announce the case and I'll let the attorneys in.
Okay, go ahead. The Court of Appeals for the 8th District. Okay.
Okay. Mr. Stevens, Mr. Benjamin, can you hear us?
Yes, Your Honor.
Yes, Your Honor.
All right. You may proceed, Ms. Gonzalez.
The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, the court will hear case number 08-20-00180-CR, the state of Texas versus Ramon P. Astorga. And Mr. Stevens, you may proceed. And just so y'all know, I think this is the first time either one of you have done oral argument by Zoom. We have the timer. Of course, it's 20 minutes, and then 10 minutes for rebuttal. And we have had, as y'all know, an opportunity to review the briefs and the record. And so with that, you may proceed.
Thank you, Chief Justice, and may it please the court. This case presents a bit of a different take on what is by now a fairly familiar fact pattern involving a traffic stop and the seizure of narcotics from a suspect's person. And in this case, we are asking this court to reverse the trial court's order granting the appellee's motion to suppress on the grounds that the tribal officer who stopped the appellee and searched his person at the Pueblo Tribal Police Department headquarters did have the authority to detain him temporarily until officers from the El Paso Police Department could arrive. And secondly, reversing the trial court's order on the ground that the search of the appellee's person at the Tribal Police Department headquarters violated the Fourth Amendment's reasonableness requirement. The facts in this case are not particularly in dispute, but I will go over them briefly. In this case, Officer Alarcon of the Pueblo Tribal Police Department observed the appellee making an illegal turn out of a parking lot belonging to the Isleta del Sur Pueblo government, in particular the Speaking Rock Casino. The officer stopped the appellee on a public road that was adjacent to reservation property. I will note that in the lower court, the appellee did not contest the validity of the traffic stop. They conceded the validity of the traffic stop in the trial court. After stopping the appellee, the officer noticed two open containers in the vehicle, and as he was going to retrieve them, he saw what appeared to be a methamphetamine pipe that was also present on the floorboard of the vehicle. The officer seized the pipe and detained the appellee and the passenger in the vehicle, put them in the patrol vehicle, drove them to the Tribal Police Department headquarters, and began to hold them there until an officer from the El Paso Police Department could arrive to take over further investigation and prosecution of the case.
Counsel, let me stop you there. So according to Officer Alarcon's report, he initiated the stop right around 12:30, 12:32, something like that. And then the video shows the stop itself took about 40 minutes from when he stops him to when he goes back to the station. But then the El Paso police report says the time reported to them was 5:10. So I mean before, so it looks like there's almost 5 hours between the initial stop and when a call was made to the El Paso Police Department. So I guess I'm not following on, I mean, this doesn't really seem to line up with Cooley where you're detaining somebody until the police arrive when it takes you almost 5 hours to call the El Paso Police Department in the first instance.
I understand your concern, Your Honor. It's not clear from the record as to whether that was the time that the Pueblo Tribal Police Department made the request for the officer to arrive, or whether that was the time that the El Paso Police Department officer was able to respond to the Tribal Police Department headquarters. So it's not clear exactly when the Tribal Police Department made that request and how long it took for them to actually respond, for the El Paso Police Department to respond to the scene. But even so, we would still argue that this constituted an investigative detention under Cooley and associated case law, regardless of the length of the detention. Because it's
Yeah, if we agreed with the trial court that this was not a detention but an arrest, where does that leave you?
well, under Cooley, this particular type of interaction is not considered an arrest, but rather a temporary detention. In that particular case, the officer transported the defendant from the scene and held him at the Tribal Police Department headquarters for an indeterminate period of time. It's not clear from the Cooley opinion exactly how long that was. But even so, the Supreme Court treated that law enforcement citizen interaction as a temporary detention rather than a formal arrest. And so state argues that, like the Cooley case, this would constitute a temporary detention rather than an arrest.
So are you saying then that, let's say they detained him for an entire 24 more hours, it would never arise to being an arrest? That entire time period, it remains a detention?
Your Honor, I don't know, just simply because the Supreme Court did not address that particular issue, because it was not raised in that instance. What happened was that appeal formed out of a challenge to the officer's authority to temporarily detain a non-Indian offender for violations of state or federal law. The Supreme Court subsequently remanded that to the lower courts for a determination of whether sufficient probable cause or reasonable suspicion was present to continue, or rather to justify the defendant's detention. So the Supreme Court did not address that. So I can't give you a firm answer on that.
So maybe I don't think I articulated my question well, sorry. I guess what I'm saying is, what I heard your answer to Justice Alley's question was that applying the precedent of Cooley, the circumstances of this case indicate it's not an arrest, even assuming it took 5 hours before a call was made. It just, Cooley provides that it's not an arrest. And I suppose I'm trying to understand, does that mean we don't apply an objective test to the circumstance, or do we just rely on Cooley?
Your Honor, I would argue that we would just rely on Cooley because the Supreme Court has characterized that type of interaction as a detention rather than an arrest. The Supreme Court did not note in its opinion that it, perhaps if the defendant had been held for a very long period of time, that it would somehow become an arrest at that point. They just characterize it as a detention and did not. It did not explicitly take into consideration the length of the interaction between the Tribal Police Department and the suspect.
In Cooley, though, didn't they? I mean, the officer sees the vehicle parked by the side of the road. He goes up to it, and there's suspicious activity. There are guns and whatnot. But I thought that he then called a BIA officer or maybe a state officer who then arrived at the scene And then they directed that he take Mr. Cooley to the, I guess, the tribal headquarters.
It's my understanding that another Bureau of Indian Affairs officer arrived. Another officer licensed to the Bureau of Indian Affairs, presumably like the officer who made the initial stop. And I could be wrong on that, but I'm pretty sure it was another BIA officer who responded to the scene and directed him to transport the suspect to the tribal police department headquarters.
So let me, if I may, Mr. Stevens, so let me see if I understand this correctly. So your position is, or the state's position is that Mr. Astorga was being held temporarily pending an investigation for the El Paso Police Department. This was not a temporary detention for the tribal officers to investigate. Is that right?
That's I think if I'm understanding you correct, Chief Justice, Officer Alarcon's testimony at the motion to suppress hearing indicates that in these sorts of situations, tribal officers will detain suspects for violations of state law until local or state law enforcement can arrive, and thereafter the local or state law enforcement officers will make the determination as to whether to arrest the suspect and present the case to the DA's office for subsequent prosecution. I hope that answers your question.
No, it does. Thank you.
Okay, thank you, Your Honor. And so I'd like to talk a little bit about the standard of review in this case, because the trial court granted the motion to suppress based on the written copy of the peace code that was supplemented into the record, and it did not rely on Officer Alarcon's testimony in coming to its ultimate conclusion of law that the officer lacked the authority to detain or arrest the appellee. And because the trial court's conclusion did not rest on a credibility or demeanor determination, de novo review of the state's first issue would be appropriate in this case. And likewise, regarding the second issue associated with the search of the appellee's person at the police department headquarters, the Court of Criminal Appeals has repeatedly stated that determinations of reasonableness under the Fourth Amendment should be reviewed under the de novo standard. And I believe the state's brief does contain a list of those cases from the Court of Criminal Appeals. And so we would argue that de novo review of both issues on appeal is appropriate.
What about the difference between arrest and detention? Because I guess they're clearly, Officer Alarcon was saying kind of maybe some different things. He said he did a search incident to arrest, but then later says, look, I'm just detaining, these people. And then I think Officer VR, when the El Paso Police Department arrived, said that they had arrested Mr. Astorga for, possession of the pipe. So is there any credibility issues there that we have to consider in determining whether this is an arrest or just I guess like a Terry type detention?
Well, certainly the trial court is in the position to make those credibility and demeanor determinations regarding whether the appellee was either under arrest or detention. But that being said, ultimately it never. So in the lower court, the appellee never argued that his arrest was illegal based on a lack of probable cause or reasonable suspicion, but rather only on the lack of the authority of the officer to detain him. And so, yes, it's true that the trial court can make those credibility and demeanor determinations, but even so, its sixth conclusion of law expressly noted that it was basing its conclusion upon the written peace code that was supplemented into the record. And so even though, yes, the trial court can make those credibility and demeanor determinations, the trial court never, or at least according to its conclusions, never based its express conclusion on the officer's testimonies. And so we would again argue that de novo review is still appropriate because it was based upon the written copy of the peace code.
So in addition to the peace code and the de novo standard of review and the application of Cooley, is the state relying on any other precedent?
Yes, Your Honor. So there are several, the Cooley opinion relies on several older cases from the United States Supreme Court and other courts, in particular, Montana v. United States, which is 450 U.S. 544, which is a 1981 case from the Supreme Court, and Straight v. A1 Contractors, which is 520 U.S. 438, which is a 1997 case. Those cases stand for the proposition that although tribes generally do not have criminal jurisdiction over non-Indian offenders, they nonetheless do have inherent sovereign authority to regulate and take action against behavior that directly threatens the health, safety, and welfare of the tribe. And in Cooley and in several other cases, the courts have expressly recognized that transportation of contraband is one of those threats. And so that was part of the rationale for the Supreme Court's decision in Cooley and I believe in another case. I think it was Ortiz-Barraza v. U.S., which is cited in the state's brief, as well as State v. Schmuck, which is also cited in the state's brief as well. Does that answer your question, Justice?
Yes, thank you.
Thank you, Your Honor. Okay. Now, the appellee, I anticipate the appellee will argue that there is a lack of some sort of agreement between the Pueblo Tribal Police Department and the El Paso Police Department or some other state or local law enforcement agency that shows some sort of cross-deputization agreement or some agreement to enforce the laws for the Pueblo Tribal Police Department to enforce state laws and turn over suspects seized under state law for subsequent prosecution by the local or state law enforcement agency. But the Supreme Court in Cooley expressly noted that under the statutes that vest the tribal officers with authority, such as 25 USC 2803 and other associated statutes, they stated that Congress evinced an intent to give the tribal officers authority to enforce state law anyway, regardless of whether there exists some sort of cross-deputization statute. So the fact that the record does not indicate the existence of some sort of a cross-deputization agreement between the Pueblo Tribal Police Department and the El Paso Police Department should not matter in this case because as the Supreme Court noted, the officers have and the tribes have inherent sovereign authority to regulate that sort of behavior through the enforcement of state or federal law. And I see that I'm running short on time. So if the court does not have any further questions, I would yield the balance of my time and reserve the rest of my argument for rebuttal.
All right, thank you. All right, Mr. Benjamin.
Thank you, Chief Justice, and I apologize. On Zoom, I'm holding my breath, trying to find out if I'm going or not. I appreciate the court, Chief Justice and Justices Alley and Justice Palafox. This is not a complicated case. This is black letter, easy to follow law. You cannot detain an individual for 5 hours, 24 hours, even just on paper, the hour and a half or more, and call it a detention. It becomes an arrest, and case law is rampant with that. But this was not, there's no even, I guess, argue, or shouldn't be an argument. It seems that we're here and there is quite a big argument, but this was a full-blown arrest that turned into a detention with a strip search for what Officer Alarcon in the court's finding of fact number 16 says that we don't do that in our policy. We are a civil court. And so this is an individual who was being detained according to the state and then fully strip searched, and not only fully strip searched, then was told to remove his underwear for what the proffered action was, a civil action of either a petty fine or up to a $2,000 fine, I believe. And when you can compare that with Cooley, where the court found a glass pipe, and then, as the court pointed out, an official from the Federal Bureau of Indian Affairs arrived. That was because the officer there, when he stopped Cooley, saw semi-automatic rifles, fearing violence, and then in plain view saw a plastic bag that contained methamphetamine. None of those facts exist here. And this was there, and as Justice Alley noted, he was then directed to be transported to the Crow Police Department. Here, we have an officer who observes a civil violation of an open container, then crawling around in the car, finds a pipe that is not listed or nobody says is in plain view until viewed, but that's still a civil violation. And so then they are not detained. Officer Alarcon in the court says that they're arrested. And so that's a finding that I think is extremely important. I want to get sidetracked for a second with one difference that I don't think is overly important here, but I think it is worth noting. One major difference between Cooley and the Isleta del Sur Indian reservations is jurisdiction, because the court in Cooley says that there is no divesting statute. As opposed to, and once again, you get off your notes and I apologize, but there's no divesting statute. That's at 1643 in the Cooley opinion. And as a backup to that, Montana is a public law 280 state, where the tribe has been given criminal jurisdiction. Texas is not. Isleta del Sur is not only not a PL 280 state, but the Restoration Act divested all criminal jurisdiction.
Doesn't the Restoration Act just say that basically the state and the city have criminal jurisdiction within the boundaries of the Pueblo? But I mean, it doesn't say that the Pueblo has no authority, does it?
I would agree with you, Justice Alley, but more importantly, it's the interpretation, because then if we move to who is a peace officer under Texas law, that's listed in Texas Code of Criminal Procedure 2.12, and then added after the fact is 2.126, which, and I'm going to butcher the names, and I apologize to the Cocheta Indian tribe, but the Cocheta Indian tribe, which was part of the Isleta del Sur Restoration Act, their officers are designated as peace officers. The Isleta del Sur officers are not designated as peace officers. And so they're government actors, but they're government actors that have been limited to civil, and as Officer Alarcon said, a civil jurisdiction. And so as a framework, I would suggest that the problem with this idea of even a detention, but as the court found it's an arrest, is Terry v. Ohio allows for a reasonable detention and investigation if officers can point to articulable facts of a crime. Here, the open containers, and then the search and the location of the pipe, the glass pipe, are not facts that justify a criminal arrest. They're facts that justify a civil fine. And so there is, on the side of the road, there is no articulable facts of a crime. Matter of fact, there are no articulable facts of a crime until we have an informant tip later on.
Would the tribal police have any authority to conduct a limited investigation of a violation of the peace code And I guess what I'm asking is, I guess there's this pipe that seems to be on the passenger side of the vehicle. I guess the female passenger was eventually the one charged with it. So the tribal police, do they have any leeway to do an investigation to try and determine whose pipe that was before they wrote, I guess, a civil ticket for possession of it?
I think that phrased as you did, Justice Alley, they do have that discretion to do that investigation to find out who owns that pipe for the civil investigation. I think that Cooley gives them some more authority that's not stated, but the court said that Montana fits like the second prong of Montana fits like a glove. And I apologize, I'm using my hand to demonstrate. But the issue there was that something that affects the health and safety is what they were relying on when they allowed Cooley's officers to detain. And that's where the officer there feared violence and saw saw semi-automatic rifles and saw a bag of methamphetamine. Here, there is no violation of a health and safety type because the Isleta del Sur tribe has determined that a glass pipe or an open container are even different levels of civil violations. And so there's no, it may boggle the mind for those of us who know that or who have a different opinion, but that's what the tribe has determined is a civil violation. And so I'd argue that Cooley's second prong under Montana, the health and safety, doesn't apply here. But I want to skip a part and go to the state has recharacterized what the trial court did here. The trial court did not believe Officer Alarcon. Stated that the state tried to fix that and supplemented the video, and the state then said that exhibits C and D did not were not credible and didn't track with Officer Alarcon because the court determined that an arrest had occurred, referring to its findings of fact under finding number 4, finding number 22, finding number 23, and these are where the court quite clearly. And having been a prosecutor, it always stings when the court says, I do not believe your officer, because that's how we get to a suppression is we believe that the officer told us what we want to prosecute on. And so, but the court's conclusion of law number 3 cited, and I'm getting real confusing here, I apologize, but cited that we are a civil court when it was determining that the peace code didn't support an arrest, but it wasn't interpreting the peace code. It was slamming, and I use that term because when a court says that many times that somebody made misstatements or the facts do not support Officer Alarcon's testimony, so I would argue, having been in that position many times, is a fancy way of saying that they don't think he was telling the truth. They don't support that, but that's the court's credibility determination looking and listening to Officer Alarcon. And then the court's conclusion of law number 4 states that state's evidence contradicts its propositions. And the reviewing court, I've heard this many times as defense attorney, must make all the factual determinations in the light most favorable to the trial court. And here that's not hard to understand why, because black letter arrest or detention type law says that there's no way to style something that ultimately becomes a strip search as anything other than an arrest. Officer Alarcon, and the court pointed out earlier, stated that it was a search incident to arrest and then back stops on that. And so the court determined in its finding of fact number 34 that the strip search by Alarcon occurred prior to being turned over to El Paso Police Department. That's not simply a detention where a federal officer arrives and you say, and the federal officer says, you're on scene, you have a squad car, you transport, I can't think right now, I apologize. You transport this individual to your station. That all occurred at the scene on Cooley. And it's important to note that in the concurrence of Cooley, Justice Alito states that if the trial officer has probable cause to detain the motorist for a period of time reasonably necessary for a non-tribal officer to arrive on scene, I think the court would certainly note it had concerns when we start getting into time reasonable necessary. When you look at Rodriguez, which 15 minutes for an officer to continue on to another topic is a time that is outside of the time reasonably necessary, I think that the court would certainly enlighten us if it was 2 hours, 3 hours, 4 hours, 5 hours, and so forth. And so the idea that Cooley was some large amount of time where they were standing on this roadside, I don't think is supported by the record. And I don't think is something that this court should infer from Cooley, because Cooley simply talks about and a detention. Is an individual detained? That's something this court deals with on a daily basis, I would assume in the criminal cases that are here. But and so Cooley allows a detention without Cooley allows a detention, but not an arrest. And so the Texas violations, the state said that we didn't argue that down below. We weren't required to. We had a good argument. We're not required to argue any and all theories down below. The court is allowed to support its ruling by any theory that was presented, but we're not required to argue that. And that's one of the issues with preservation. But without waiving the argument that preservation was on state law was not done, because the trial court clarified what portion of law the state was referring to. And Ms. Moore said, or the court said, I want to make sure that while the eventual stop was off tribal land, that the law, so to speak, that the officers relied on was from the traffic code, which I think it was. Ms. Moore from the state says they were. The court says that's what I heard. And Ms. Moore says that's his testimony. That's why I asked him, was that a violation of tribal law? Is that the law that was applied at the time because it was the stop? And the state relied on that. The state did supplement, and supplement doesn't seem to have helped the state, because as we look at the findings of fact, the court finds it states in conclusion of law 4, it's a credibility determinant. Based upon the El Paso Police Department offense reports and supplements, the court concludes that officers' testimony about how the defendant was not arrested, only detained, does not squarely fit with either the state's exhibit C or D, both of which clearly show that the defendant was handcuffed, searched for a second time, then placed under arrest soon after tribal officers found the glass pipe inside the defendant's vehicle. And so that's not a relying on the traffic code. That's the exhibits the El Paso Police Department is exhibit C. D is the video. This is a court squarely looking at what she was presented with and making a determination of credibility against the state. And so the Texas violations that were not preserved or challenged by the state, but I think are applicable, are that there was no violation of Texas law in the traffic. There's no requirement to have a turn signal displayed turning out of the parking lot. That's a tribal violation. It's not a Texas violation. I already mentioned this. Sleda del Sur were not peace officers. Article 2.126 provides that to the Cacheta Indian tribes, but the Sleda del Sur tribe was carved out. There's a stop outside of the jurisdiction of Texas, and that's violative of the Fourth Amendment. This was not a breach of peace or a felony at the time of the stop, or even at the time of the arrest that the court identified in its conclusion of law number 4. And so therefore, somebody who's not a peace officer does not have the ability to detain anybody. Nobody, including the state, is going to argue that at the time of the location of the pipe for a civil violation that Mr. Cooley was allowed to leave. He was arrested. And so I apologize, I lost my thought. And so if the search is done under the tribal authority, then the Indian Civil Rights Act would suggest suppression, as the trial court did here. And I think it's important to note, the trial court didn't suppress the open container. The trial court didn't suppress the pipe. The trial court only suppressed the methamphetamine that was located under the defendant's underwear when he was strip searched. It wasn't even visible when he was stripped down to his underwear. It was only after he was forced to remove his underwear that the methamphetamine was located. And so there are no facts that support the veracity, the reliability, or the basis for the informant the girlfriend, the friend, the female in the car for her knowledge that those narcotics were a bulge, was not a hernia, but rather was drugs. And so the state had spent some time on the Bell factors, the scope of the particular intrusion. The cases I cited under the ICRA talk about it's an extreme intrusion for a strip search. The manner in which it was conducted at minimum an hour. If we start at 1324 and work to the station, it was minimum of an hour after he'd been arrested. The justification for initiating this strip search were 2 civil violations. And the place in which it was conducted in a police station where he was not directed to be taken by a federal law enforcement officer, a state law enforcement officer, but where he was taken by an officer who is not under the Texas code, a peace officer. And so the last issue that I'll address is the issue 3, credibility, or is it a matter of law? And I think that the court has made clear in its findings of fact. Once again, I apologize if I'm naming them. I'm numbering them simply because it amazed me the number of times that the court said that it did not believe Officer Alarcon. 11, 19, 20, 22, and 23, that she did not find officer credible on those points. That's not something that goes towards a de novo standard of review. That is, you failed to convince the trial court that your witness had any credibility. And so the court found in conclusion of law 4, and I've said this before, that the testimony did not fit with the proffered evidence. The entire suppression was grounded on the non-believed testimony of Officer Alarcon that was a full-blown arrest versus a detention. And the peace code can't be cited to change these very damaging findings. And so we would ask that the court respectfully upheld the trial court's determination and the suppression of the methamphetamine that was located on the defendant's groin. Thank you. And I would yield.
Thank you. Mr. Stevens, rebuttal.
Thank you, Your Honor. So I'd like to respond quickly to a couple of issues brought up by opposing counsel.
And I'm gonna stop you right there for just a minute because I have a question. And
yes, Your Honor.
So let's say hypothetically, because you may answer this question for me or discuss this in your response, but hypothetically, let's say that the tribal police officer has the ability, even though they don't have any criminal jurisdiction, have the ability to detain for the purposes of an investigation or the purposes of holding somebody until the state law enforcement can get there. So let's assume for the moment that they have that ability, that this was a temporary detention, that they had called the El Paso Police Department, and it took 3 to 4 hours to get there. So let's hypothetically assume all of that is occurred and is valid. My question right now is, what authority did they have to conduct a search? They got a tip that Mr. Astorga may have drugs. My understanding is he's in a holding cell, and they do the search. So what authority do they have? If the El Paso Police Department have been called and are coming, and they're the proper agency to conduct the investigation, and the tribal police have the authority to temporarily detain but not conduct the investigation.
Your Honor, it's my belief that Officer Alarcon did testify that it's standard procedure for those officers to conduct searches of suspects that are. Okay,
all right. But Mr. Stevens, I'm sorry. While I understand that may be something that they do, that's not my question. Legally, what is the authority they have to conduct that search?
Your Honor, I do not know. It's not clear from the record as to what express procedures they have other than Officer Alarcon's testimony. Stating
and Officer Alarcon is not a lawyer. I'm just really finding it difficult to see what legal authority they have to conduct a search. I could see a search for weapons, and they did a pat down when they pulled them aside. I can see if somebody had made an allegation regarding weapons, that you might do a little bit more intrusive search once you got to the station and he's in the holding facility or the holding cell. But when the allegation is drugs, I don't see the justification for the search.
Well, Your Honor, the courts have, and I'm not speaking of statutes or written procedures or anything like that, but courts, including the United States Supreme Court and the Court of Criminal Appeals, have expressly recognized the substantial government interest in preventing suspects from possessing contraband in some sort of holding cell type enclosure. That's discussed at length in the state's brief, simply because if detention officers or police officers were to allow suspects to continue to possess contraband, they could either consume it, destroy it, conceal it within the holding cell. And the courts have repeatedly recognized the significant government interest in preventing suspects from doing so. And so there is that interest on the part of law enforcement to prevent that sort of thing from happening.
I guess my problem with that is that technically the tribal police don't have criminal jurisdiction, so they're not technically they're not law enforcement.
So, Your Honor, they are federally licensed officers. They're licensed by federal statute. I think there's some confusion here as to what jurisdiction means. It's my understanding that, yes, under Public Law 189, the state does have criminal jurisdiction over the reservation when it comes to the prosecution of non-Indian offenders for violations of state or tribal law. But these officers still do have federally vested authority to conduct what we typically would assume to be normal law enforcement operations, such as powers of detention and arrest for violations of state law, and that's specifically mentioned in the Cooley opinion, that these officers do have that authority, that inherent sovereign authority, and the tribes do as well, and to do that. I hope that answers your question, Your Honor.
Yes, it does. Thank you.
Okay. And I'd like, I'm sorry, go ahead.
Just maybe to pull you in a little different direction, Counselor. If we found that this was an arrest, and I know you would disagree with it, but if we found that it was an illegal arrest at the scene, does everything after that then really kind of become moot? In other words, it all becomes what fruit of the poisonous tree? Is there any way that if we found that this was an illegal arrest, that there's any way that you could salvage the evidence?
Well, Your Honor, if the court was inclined to agree with the trial court that this was an arrest, although I will note that the trial court did not suppress the evidence based on a finding or a conclusion that this was an illegal arrest, but rather, for lack of probable cause, reasonable suspicion, but rather only because the officer, according to the trial court's conclusion, did not have the authority to detain the appellee for violations of tribal law.
Is there anything in the Peace Code that gives them that authority to detain someone to investigate a violation of the Peace Code?
Not within the Peace Code itself, no, Your Honor.
So it would have to be really from Cooley, some kind of an implied authority from Cooley.
Yes, Your Honor. Yes, that the Cooley opinion states that reservations typically have that authority. Yes. Okay,
and so, all right, I guess kind of two prongs. If they're holding Mr. Astorga for the El Paso police officers to come. And I know all this record was developed pre-Cooley, and now of course, we're looking back and applying Cooley to a situation the lawyers didn't know about. But whose burden would it have been to say, okay, the El Paso Police Department was contacted at this time, and they showed up at this time, and that was a reasonable period of time? Whose burden would that have been?
I believe that would have been the state's burden.
Okay, and then we're just talking about an investigation of the peace code, assuming that they have that inherent authority. What investigation were they really doing? I mean, I think they testified they weren't trying to get scrapings off of the pipe to test it. What during this 3 or 4 or 5 hour period, whatever it was, what was the investigation that they were performing?
Well, Your Honor, it's not that they were performing an investigation. It's that they were detaining the appellee until local law enforcement could arrive. That is how the state would characterize that particular type of interaction. It's because at that point, obviously, the investigation for the paraphernalia has concluded at the time that the officer sees it. And so, again, this is a temporary detention in order to allow the officers from the El Paso Police Department to arrive to conduct their own investigation and then therefore decide whether to pursue charges and arrest the defendant and present the case to our office.
Thank you.
And so, I see my time is running up, but briefly, I'd like to touch on just the underpinning of any Fourth Amendment question is going to be reasonableness. And in this case, the Supreme Court, in the Cooley opinion and in other opinions, has expressly noted that there's this reasonableness associated with not simply issuing a civil citation to a non-Indian offender for an obvious violation of law and simply setting him free in order to carry out other crimes. And so we would argue that that reasonableness factor applies here, that is what the officers did in this case was reasonable. And we would ask this court to reverse the trial court's order granting the motion to suppress and to remand the case back to the trial court for further proceedings. And if the court has no further questions, I'd like to thank the court for the opportunity to argue.
Now, any further questions?
No.
I don't think we do. I think we peppered you enough with questions.
Thank you, Chief Justice.
It's baptism by fire. But anyway, thank you, gentlemen, both for your excellent arguments today and your answers. The case will be submitted based on your briefs and your presentation today. So thank you for that. I appreciate it.
Thank you, Your Honor.
Time, Your Honor. I appreciate it.